Hello and welcome to another edition of Law and Democracy, a podcast of the election law program at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law Program. And in today's episode, we are delighted to have with us Jacob Eisler. He is the James Edmund and Margaret Elizabeth Hennessy Corey Professor at Florida State University. And in addition, I'm joined today by Ned Foley, the director of our election law program, and then two colleagues who are senior fellows of our election law program, Terry Enns and Tony Goggin. It's great to all be together today. And Jacob is here in some substantial part to help us be aware of a really exciting conference that he organized at Florida State University just the end of last week. With that, I'll let Tony kind of pitch a first discussion topic for us.
Sure, absolutely, Steve. Jacob, could you tell us a little bit about the background of the election law conference that you just hosted at Florida State and what some of the highlights were of the conference?
So this is the second iteration of what we hope is going to become a sort of continuing rotating conference on election law. The first iteration was hosted last year at Washington University in St. Louis by Travis Crum. And, afterwards I approached him. I said, is there, he said, look, there hasn't sort of been a dedicated scholarship oriented election law conference for a while, sort of pandemic disrupted sort of some of the regular election law events. I said, look, I can see if we can host another one. I went to our dean at Florida State, and she, I thought I was going to have to grovel, and instead I just get to know that would be great. We'd be happy to support you. And everyone at Florida State was incredibly helpful. And the focus of this conference was really scholarship. Right. The goal is to bring together some people who are working on cutting edges, no particular subfield focus within election law, but really just be as intellectually fertile as possible. And I'd certainly say it satisfied that. I mean, what I'd say is the scholarship I saw, I think, illuminated some of the challenges and frontiers that election law, both within the doctrine and within the scholarship, is facing. And that, I would say, for someone who attended, was the highlight. Seeing these different pieces of scholarship cutting across different areas, different methods, but together capturing a transformation in what election law means and what the main debates are going to be, not just now, but I think into the future. So I would say, Rick Hazen has just published a piece in the Yale Law Journal, and I was speaking with someone else about it. And they said, look, I think this is really about its continuation of the rights structure debate that has been present in election law for decades. Nick Stephanopoulos, our keynote speaker, wrote about it in his book, Aligning Election Law, which, of course, with Ned and Steve, we got to discuss extensively at the Ohio State Conference this past spring. And what I think you're seeing is an attempt to move beyond makes it sound like there's rejection of the debate. I would say evolve to the next stage of discourse and reintroduce some theoretical questions that I think maybe have been traditionally neglected, moving through two main veins, right? One is a return to certain theoretical underpinnings of election law. And I think this was particularly apparent in Ash Ahmed's piece, Two Faces of Representation. I think it was apparent in Sarah Hahn's Alternative Democracy. These were pieces that looked to sort of deeper cross-cutting themes in election law that are manifesting the doctrine, but it will take scholarship to fully draw out. And Ash did something that I'm very sympathetic to, and sort of driven my scholarship is looking to the norms that are present in election law doctrine. Sarah Hahn's paper was this fantastic, I think, early stage project on election law and democracy and its relationship to capitalism. And I think they both made quite bold claims, but I think what was clear in both of them was an attempt to expand the theoretical scope of election law, to bring in norms that lie beyond the standard right structure debate that's been used to structure the jurisprudence, but also has been extremely prevalent in shaping election law as a field. Now, I also think you saw attempts to recognize that there are certain points of stasis in election law theory and election law scholarship, more specific points of tension, like Josh Seller's Hollow Parties Reconsidered, the question of if parties are weak or strong. I mean, I think I've said this before. I think it just shows you how rapidly the discipline has been changing. Back in 1997, Sam Sakharov and Rick Pildos were saying parties are this real potential threat to democracy. 20 years later, Sam Sakharov is saying the problem is, and one of the reasons we've had this sort of populist resurgence in the U.S., parties are too weak, right? So you have this transition within election law theorizing about parties, and I'd be very curious to hear all of your perceptions of it. I think what Josh was trying to do was say, well, what are the shared underlying values that are driving our conceptualization of parties, and how can we break down parties' engagement in democratic self-governance so that we don't need to use this binary? So maybe that's another way of thinking about what this conference tried to do, is sort of break through existing ways of conceptualizing ones and zeros in election law and say, well, what are the underlying principles? I think you also saw this in Yoon-Sik Kim's work on campaign finance, where he said, look, for a long time, the concern was plutocracy, right? But both due to changes in how media is operating and due to the way the 2020 and 2024 elections played out, the relationship between wealth and self-rule is much more complicated than it was when you had I would say simply more stable, more conventional broadcast media form instead of this much more chaotic and still evolving media environment. And then you had, in sort of the general theories, I'm just looking at the syllabus. I'd also say Laurie Hibbringham's work on misrepresentation. I think attempts to cut to the norms that underlie this, that have been present in the scholarship, maybe not brought to the surface until recently.
Wow. Can you say a little bit more about the paper that discussed the relationship between election law and capitalism? Like what
So there were two. There was Sarah Hahn's paper on alternative democracy. And it was interesting as these two sort of, I think, existed in an interesting form of tension, a complementary tension. Sarah Hahn's paper argued that you're seeing an attempt by essentially the new economic elite, particularly tech billionaires, to transform democracy to look more like a sort of techno-libertarian utopia, right? Maybe utopia is too aggressive a word, but to have democratic process reflect the norms that are often seen as desirable in these sort of technocratically driven frameworks that I think often comes at a cost to rank and file voice, right? Or sort of to synthesize Sarah's view. I think what's interesting is Yoon-Sik's paper on the campaign finance paradox pointed out that the traditional modes of exerting economic influence, let's say basically, phrase it crudely, bribing representatives by buying campaign finance ad. That was the traditional concern in Buckley versus Vallejo. And given the resilience of that doctrinal framework, that's still how election law makes sense of the influence of wealth. Both of these papers from different sides were saying that understanding of how wealth influences politics by bribing officials is no longer adequate, not just because it has maybe the theoretical infirmities it had at the outset. People have been observing this for decades. Dan Ortiz, David Strauss, I think, the famous hydraulics paper by Sam Sakharov and Pam Karlan. I think these observed some of the deficiencies at the outset of Buckley. What I think was interesting about these papers is they observed how changes in how democracy operates is making this relatively stable, but also linear understanding of the potential disruptive effect of wealth is no longer adequate. Right? We need to look to how society is changing, how democratic preference is being shaped in ways that the older bribery-based framework just can't capture.
So if I'm understanding it, basically saying that the voter preferences are a product of the regime, not exogenous to the regime. Is that the idea?
I think so. I think that's part of it, but I think that it operates through these underlying changes in how representatives, how political elites are interacting with economic elites, and how both are speaking to voters. I mean, the really obvious place to go with this is the rise of social media. You look at Twitter. How did Musk and Trump have a corrupt relationship during the 2024 election? I think that's a difficult question, one that's certainly hard to fit into a standard bribery framework. It looked more like the sort of cooperation among individuals who have a certain level of social power. But understanding that power is the simple infiltration of wealth into politics as a form of bribery just doesn't make sense anymore, right? One of the things that I think is interesting is how this intersects with other areas of election law that were present in the conference. In particular, I'm thinking about parties here. The role of parties sort of destabilizing, and the comparative weakness of parties in the U.S. as allowing these new forms of socioeconomic power to shape electoral outcomes and shape broader political dynamics, including ones very much at the grassroots level.
I'm trying to think how to utilize, and these insights seem interesting from a kind of a sociological perspective, or maybe even a normative critique of our system perspective. But I'm having a harder time seeing how we operationalize this as an understanding of election law itself. It's easy to critique the court's current campaign finance jurisprudence, but seems futile in the short term anyway. And just how we understand how the rules of our electoral system produce democratic government. And our assumption has been, despite the faults that we may have in our system, we have a version of democracy that is sustained by the election law that we have. And I can't tell whether these papers are challenging any of that sort of fundamental assumptions or not.
So, Ned, I'll sort of give you my view, which is informed by the First Amendment more generally. I tend to agree with, I think, the critical thrust of what you're saying. I do think there's been an interesting and somewhat long-burning trend in First Amendment law to say we need a more proactive, less deferential, less negative conception of the First Amendment. Cass Sunstein, sort of going back to free speech now, making this argument. Probably one of the more prominent recent articulations. This is Marianne Frank on her work on the pathologies of current sort of negatively conceived free speech law. I think that's the sort of thing that academics love to say. We need to pursue. We need to adopt a concept of the First Amendment that advances the social good. I'm maybe a little bit suspect of that because it does seem to create a potential lever for governmental social control that I'm not sure I'm entirely comfortable with. And based on what you said, I suspect you'd also have at least some inclination towards the more classical tradition. Is that right?
Yeah, I mean, it seems to me the biggest free speech threat from an election law perspective at the moment is this brand new New York the Trump suit against the New York Times. Because, it's one thing for Trump to get a settlement out of Paramount and CBS, but if the government in power is really able to shape the media landscape by intimidating broad swath, and I don't know that the New York Times is going to respond by a settlement or caving, but I don't think we've ever seen quite as aggressive a threat on a wide swath of media as we've had this week. And I don't know whether he meant it or not, but Trump says he's going to go after ABC News and Jonathan Karl. So, going after major media outlets, and a lot of them could really, I don't know. I just think I think election law needs to worry about that, maybe even more than campaign finance law at the moment.
So sort of two quick observations about that. One is that I think this does intersect with some of these themes of the changing media landscape, where Trump can afford to alienate the media. Some, traditionally politicians wanted some sort of reasonably amiable relationship with the major organs of public information. Now Trump can go straight to Twitter or Truth Social, right? So he can afford to attempt to marginalize what were once, in one sense, the only games in town, right? And I think, I don't want to talk about this too much because, as you said, it's mostly sociological in one sense. I think there's going to be, I wonder if there's a broader fragmentation, right, happening due to the way that public opinion is formed now, right? Now, of course, this fragmentation fits with our classical understandings of the First Amendment, but whether or not that actually works as a matter of social cohesion, I mean, it's probably beyond lawyers' pay grade. The other thing I wonder, and I'd be very curious to get everyone's views on this, because my knowledge of defamation law is pretty much limited to what I teach in my Common Law 2 course. It seems like Trump would have a tough row to hoe here because he is the most public of public figures, right?
But I gather, and I haven't taught First Amendment class in a while, but I gather both Thomas and Gorsuch have invited reconsideration of the old New York Times versus Sullivan standard. I don't know that Justice Barrett has had occasion to weigh in on it, and I don't know where the rest of the, I don't know where Roberts and Kavanaugh are on this issue. But if there's a major, rethink of defamation law in the U.S. Supreme Court, I think, even though I don't teach defamation law as an election law issue, I sort of wonder if we shouldn't sort of bring it into the fold of election law, given the importance of, free debate as an electoral right, not just a generic free speech right.
I mean, at a certain level, this all comes down to rule of law, right? We'd like to think that the Supreme Court would recognize that it needs to, in one technical sense, be neutral with regards to the parties before it. In another sense, recognize the power of the executive. And thus, when it's the executive bringing a claim of falsity, be relatively protective of media rights in that landscape. It would be, I always wonder here, this is kind of a intuition I have. I suspect Roberts has a significant concern for his legacy. I think about the ACA case, right? And sort of transforming defamation law in response to a suit by the president would just seem to show such an alignment of the court with the executive. It would be an extraordinary move, separation of powers as well. But I think this all speaks to some of the ways that the classical, just to wrap it back to the main theme, the sort of standard framework of election law, the sand's shifting under its feet. And I think scholars are sort of recognizing the need to go to fundamental normative questions. That's how I always think of them, but also look to some of the underlying legal and social structures that supported the classical framework of election. Whether this means the sort of standard divisions of election law will be maintained, I've always thought of it as one person, one vote, districting, race and elections, campaign finance, party governance. Whether or not that will sort of have to be reconceptualized, I think, is an interesting question in response to the sort of destabilization of some of the law, but also of American politics more generally.
I can keep going in this vein. Do other people want to jump in?
The one thing I might add along these lines, Jacob, is it's interesting to think that the Citizens United decision it's only 15 years old, and that was such a wholehearted endorsement of the obviously the constitutional rights of independent expenditure groups and the value of wide open, wide-ranging political speech, and the court's conclusion that the First Amendment is most protective in the arena of political speech. And yet here we are 15 years later where President Trump's lawsuit at a certain level represents a challenge to that, not through a campaign finance context, but through defamation law. So if there were the justices who are currently on the court, who were on the court in 2010, were they to be more receptive to the president's uh, defamation case under the First Amendment. I would be very curious to know how they would square that with their Citizens United ruling 15 years before.
I mean, I am curious about what, this is, like I said, defamation law is something I've primarily just come across in the First Amendment context. The idea that the president would succeed in a defamation suit against a major paper on a matter of public interest is just extraordinary to me, right?
Well, what about the CBS settlement? Isn't the CBS settlement extraordinary?
This goes well beyond my expertise. Does their decision to settle reflect what they think the outcome would be, or just a real politique move, an attempt to, sort of avoid conflict and recognize it's going to be cheaper to settle than to defend, right?
But from an election law practical perspective, CBS, as I understand it, is both paid millions of dollars to Trump for what was most people thought was a completely frivolous lawsuit, because sort of an extortion value of the lawsuit, and the CBS is going about changing, the composition of their media identity. Now, maybe as this independent organization, they're entitled to shift from, their traditional outlook on the world to, what seems to be a more, right-leaning outlook. The First Amendment protects right-leaning views and left-leaning views, but the role that money is playing in shaping the media landscape, when you look at what Jeff Bezos is doing to the Washington Post and what what CBS owners are doing to CBS, these seem to be responses to fears of getting on the wrong side of government. It doesn't seem to be authentically chosen viewpoints. It's like we need to change our viewpoints because we don't want to cross the powers that be in Washington. I mean, and whether that has an electoral effect or not is a very complicated story about where do people get their opinions in order to make their decisions on how to cast their votes. And I don't want to assume the notion of false consciousness too quickly and that people are brainwashed into thinking things that they don't really otherwise think. But the fear of campaign finance, the reason to be concerned about the libertarian view of campaign finance is the fear that money matters, right? And it does shape public discourse. And now we're seeing the potential for public discourse being shaped through bullying tactics by the federal government. I do. No, the only other thing I'd add is, it's too recent in terms of news for me to completely process, but and obviously the assassination of Charlie Cook was a horrendous tragedy, and our society needs to figure out how to cope with that in a way that maintains a free society. But if the response to this is to have the federal Justice Department try to take away the tax-exempt status of a wide swath of organizations that are perceived to be political enemies, that, again, I think that has election law repercussions, not just broader First Amendment repercussions.
So one of the things sorry, Steve.
Well, so I was thinking again about the question Tony had posed a little earlier, that if we're in a moment where there will be some serious reconsideration of First Amendment doctrine because the Trump administration is successfully able to move the needle in a way that makes it harder for our media, our free press, to operate as they historically have done. At the same time that we have people like Sarah Hahn, as you were describing it, at least I understood it, arguing for a different adjustment of our First Amendment doctrine for purposes of rethinking what it does or doesn't say about the ability of moneyed interest to influence the political process. I'm just wondering about the tension in there and wanted to circle back to that question that Tony posed. if I understood what you were describing was the
So I think what's
corporate
sort of putting that sort of in dialogue with Ned's point, I think one of the things that's really interesting here is the way that the traditional dynamic was, well, we're worried about a libertarian challenge to public power, right? That was the traditional concern, deregulation as being problematic. I think what's so interesting about Trump's sort of weaponization of really governance, right? Like a defamation suit. This is one of the things I tell my students in my rights course. It's ultimately the government that's forcing you to pay out in a defamation suit. This is why we cover this in a course on constitutional rights. And Trump's this funny figure who kind of cuts across. And I don't know if it's unique to Trump. I mean, one of the things that I think is, he's been sort of he started running and he's really kind of burst onto the public conscience as a viable candidate in 2015. So it's been about a decade. He was not really a figure who was seen as an inside political candidate prior to a successful run for the presidency, right? And we have to ask, to what degree is he unique, sort of historically, right? To whoever succeeds Trump, both in the presidency, whether it's progressive, conservative, Democrat, Republican, or who succeeds him as the leader of the Republican Party, right? One of the questions will be, will they maintain his sort of peculiar outsider status from typical political norms? And I think one of the ways that outsider status manifests is the standard dynamics of, libertarian deregulation as a threat to sort of egalitarian public governance. One of the things I used to structure in my book that Tony so kindly held up at the earlier. Trump's weirdly cutting across that, right? You wouldn't expect a Republican person who's sort of seen as strongly aligned with private forces to be threatening the press with a defamation suit, right? That's a very strange move from a sort of standard alignment. Okay, are you libertarian, or do you believe in higher levels of public control to ensure that egalitarianism can have discourse? Trump cuts across that, and I think what was so interesting about Sarah's paper was it tried to reconceptualize the way the standard normative divide maps on to governance, right? She was saying there's now an attempt by certain private sector leaders to not merely attack governance, the sort of standard libertarian challenge to public power, but remake governance to fit their normative version of elite technocracy. Right. And she asked, is this, one of the things she asked at the conference, is this too big a project? And I said, no. I wrote to her later. I thought it was a great project. I said, look, I think you should pursue this, right? Because I think times are ripe right now for election law scholars, not merely to sort of, as I've done in my, meek career, merely look back at the doctrine, but to try to anticipate how legal changes can address the unfolding forces in democracy. Now, I do think the defamation suit is also, again, just fascinating because it must reflect. And I feel this is one of these things where, when I was 16, 18, 20, I felt like kind of had my pulse on what kids were doing. I have no idea now. Some of the destabilization of the standard dynamics, which we might say are stultifying, produce, impair political change, relationships between corporate forces, media elites, and political elites. How Trump's, remarkably enough, for someone of his generation, taking advantage of that destabilization. I don't know, right? This is one of these things where law is intrinsically conservative, I think, in the sense that it looks backwards. I don't know how effectively it can address upcoming challenges, but Ned, this is a question you sort of doing the annoying professor thing of throwing your own question back at you. But what would you think? One thing the courts could do is just knock down the defamation challenge here and say, no, this is ridiculous. You're a public figure. This needs to be resolved through public debate. We're not permitted. We're not going to find liability here. But do you think there are other sort of doctrinal adaptations that can be made in the First Amendment to accommodate these changes?
Yeah, I mean, I think holding the line is probably maybe the first thing, most important thing. And then the question is whether bolstering the line, so to speak. I mean, I don't want to be overly alarmist, but I seem to can't help but think of myself as, what Putin has managed to do in Russia and Orban to some extent in Hungary is, to shape political culture through government intimidation to the point where there is a certain authenticity to their position in power. I mean, it's not accurate for us to say that there is nothing small d democratic about Putin's Russia. There are elections that are held, ballots are cast and counted. The complaint, if it's a valid complaint, is that society has been warped to the point where, and again, I'm not a sociologist, but to the point where there's no genuine political competition of a free society that would allow, dissidents get killed, right? They get poisoned by the KGB or the successor to the KGB. I mean, there's just such a thoroughly anti-free society that you can have a formalistic electoral system, and it looks like the electoral system is functioning. Orban is his less extreme version of that, and thankfully the United States isn't close to that yet. But there's no doubt that Trump admires Orban, seems to also admire Putin, and we have mechanisms within our system to try to prevent that shift. But one of them, I would say, is our defamation law, and the thorough, the civil. People talk, about the strength of our civil society. This is a de Tocqueville point, right? In other words, and so all of this robust nonprofit sector is the buffer zone between the populace as a whole and the raw power of the government. And if the balance of power between the government and the nonprofit sector changes and is allowed to change, and the balance of power between the government and media changes in part because of new technology, but in part because of the kind of intimidation of CBS that has occurred, we may slide somewhat towards that more Orban-looking world. I hope not, but I think we need to be a little bit concerned about that.
There is one intrinsic defense that America enjoys, and that's this. We have such a high level of intrinsic social, ethnic diversity, right? I think it would be much harder to have any leader exert that sort of sway. And I think, I think our constitutional structures are still quite healthy. What I worry about more than a type of Orban or Putin outcome, what I worry about more, and this is not necessarily a novel point, is increased fracturing of American governance and American culture, right? Some of the conflict between, and I think one thing, and this would be an interesting area for future research, has there been rising state level resistance to national governance in the past decade? Clearly, this is happening under Trump, right? As he's pushing forward, aggressive new immigration policies. I think that's the one that's probably gotten the most attention. It'll be interesting to see in light of sort of the Kirk killing, and if he'll try to do other things to directly affect local policy, right? But you've seen states sort of say we're going to resist, and I think you're seeing some increasing polarization in local politics. Mamdani likely being the next New York mayor. They're going to have increased conflict between, sort of the federal level, right? Now, I think you had a much milder version of this in, say the past 10, 15 years. Now, obviously you had one spate of this during the civil rights movement, right? And that sort of stood out as exceptional. It seemed like there was this moment of resistance, which was then sort of ended. sort of had settled by the 1970s. I see that in a way as the greater threat than the type of homogeneity that could happen, that has happened in Hungary and in Russia, right? I'm more worried about the fracturing of the U.S. than I am about a single dictatorial actor, right? That's sort of my view, and I think what role can election law play in this? Nick Stephanopoulos' paper was quite technical, and it was about trade-offs in districting, and he essentially argued that given certain constraints, the idea that there are necessary trade-offs in districting might be sort of a phantasm, right? That his technical skills are pretty exceptional, and he said, look, if I put these constraints, these Senate Karcher v. Daggett constraints on a district, I can actually make one that satisfies all of them with relatively few trade-offs. Now, somebody asked a question, well, what if we pop incumbent protection in there, which is, of course, a central interest? Then he's like, well, I need to rebuild so you need to rebuild the model and see what it looks like if you add additional constraints that are often there, not in the ideal, but in reality. Nick's paper was, I think, more focused on ideal politics. What are you able to satisfy those constraints? Can election law play a non-paternalistic role in addressing this fracturing? And this is where I always wonder, is election law necessarily an ex post synthesis of preferences, or is it a mechanism for shaping preferences? And are we comfortable with law being a mechanism for shaping preferences? These are, I think, huge questions and again, I think these are ones that are normatively change the terrain of where election law has been, right? And I think those are the types of things that need to be asked as some aspects, Ned, this is kind of implicit in your question, some aspects of our civil society seem to be fraying.
And Jacob, that's really a perfect segue to your book, The Law of Freedom. And in the context of what you and Ned and Steve were just talking about, which is the fracturing of our democracy and then political fragmentation and all the different forces that are acting to undermine our institutions, what is the proper role of the judiciary in an election law context? That's obviously one of the central questions of your book. But could you expand on that, on your perspective on what role the courts can and should play?
So I think, my central thesis is that election law, the starting point, is that election law poses a unique paradox, right? I think there's sort of an impulse to turn to the courts to fix anything we don't like, right? Things go wrong, have the judges step up and hand down the right decision. Problem being, in election law, what the ultimate right decision can't be imposed downwards or contravenes the norms of democracy themselves, right? And the appropriate role of the courts, in my view, is to be an arena in which the norms are debated. And this is where I think I take in one sense, a relatively optimistic view, though it's fairly subtle in the book. I think that's exactly what the courts have done, right? I kind of reject the idea that you simply have, and this is something where I do think rule of law, Ned, I don't know if this is any comfort to you. I do think rule of law in the US is still quite robust, right? And I think justices on both sides of what would be called, from an attitudinal model, the ideological divide, are still trying to advance rule of law, albeit with very different starting premises. But I get this question from my students a lot, like, are the judges really deciding things in a neutral way? And I say, well, look, start with the basic case. You have a tort suit where somebody who's politically powerful has caused harm to someone who isn't. Are the courts still going to find the powerful person liable? Maybe not in China, maybe not in Russia, right? But in the US, I think you still would. I don't think that would be a close question. I don't think the political power could be brought to bear on the courts, at least certainly not on the federal courts, I think.
Yeah, I would distinguish federal and state, unfortunately, at least here in Ohio.
And I would say that certainly at least the federal courts still have a high level of professionalism, high level of commitment to rule of law. So I think if you look at election law, what you see is this debate over the proper role of election law. Is it to protect equality in democracy through permitting both other actors, legislatures, the executive, to enforce equality as a norm in election law design. And this would be, campaign finance is a classical area of this. Do you permit the government to come down and limit private power to have political equity? We could imagine an updated form of this. Should the government be allowed to impose relatively stringent limitations upon the use of social media, or perhaps treat social media as a quasi-public good? Right? I don't think it would be hard to see how certain scholars in the academy would probably say, look, we need to start seeing social media as a public utility and permit stronger governmental regulation. And I think there's an egalitarian wing in the jurisprudence on the bench. It certainly hasn't done that yet. This isn't an issue that sort of bubbled its way up in the jurisprudence, but you could see that as a modern manifestation of this. Where you see it is in the more classical campaign finance jurisprudence. Where you see it is in the treatment of race and election. So the question becomes, does the Equal Protection Clause, does the 15th Amendment, do these accommodate attempting to equalize power along racial lines and afford protections for the sort of traditionally disadvantaged racial minorities, such that they don't merely enjoy equal formal standing, but actually have more political power? And just to lay it out, I think that's what you saw with the great legislation of the 1960s. You had Congress saying, we need to take very proactive and exceptional steps to elevate the actual political opportunity of racial minorities. And you saw the court in Katzenbach say, okay, we're going to, these are extraordinary measures, but this is an extraordinary problem. What you're seeing with Shelby County, what I think is going to be an extraordinary case that we've all got our eyes on, is Calais. And this was a case that came up repeatedly during the conference. Sort of one of the things that came out in the socialization afterwards was people saying, "Oh, do you want to write? Do you write your article about Calais now, or do you wait until the cases come out? You don't want to get preempted by the bench itself. You don't want to be scrambling trying to rewrite your article after Calais throws your scholarship into disarray." Calais, of course, being a case about the status of VRA Section 2. But I think I think the Jingles test is extraordinary. And I think SFFA kind of shows the way the court is leaning right now with regards to the remit of the Equal Protection Clause and its understanding of the interaction in race and governance, where it wants to impose a more formalistic concept of racial equality that treats all individuals as formalistically equal, regardless of what critics would call social realities, right? And what the Jingles test does, current application of Section 2 does, is really say, no, social realities demand that we give some unique protections to racial minorities. That's a tough sell before the current court. The real question, I think, is it's going to be unfortunate semantically, jurisprudential prudence, right? Does the Supreme Court want to upend sort of stable points in election law like that? I do think that the passive virtues are something the court turns to all the time. I think post FFA, the decision not to opine on the Jefferson County magnet schools case reflected the desire not to change the law too rapidly. I suspect the current bench would certainly, if faced with a novel instruction to come with some implementation of Section 2 of the VRA, certainly would not adopt something as structural as the Thornburg v. Jingles test. But I do wonder if the court is ready to further destabilize kind of fixed points in election law. Sorry, Tony, I kind of took your very nice question about my book to bear on the current jurisprudence, right? Which I think is fascinating. And just to lay out the other trend in the jurisprudence is one, what I call the libertarian trend, which is the role of the court is to limit the government and protect individual liberty qua individuals, and limit the government's interventions to bind and channel public power, right? That the court really, and this is in one sense a more familiar role, the court limits governmental power, right? The challenge of election law is because election law is precisely about that moment of transition between private preferences that become public through being collective and the government, it's a much more normatively complicated decision, right? Do you ensure that all individuals are equal through governmental intervention, or should the court attempt to protect the formalistic equality of individuals across domains?
And one thing I might add, Jacob, is another element that complicates this is what Nick Stephanopoulos, who you referred to before, has described as the racial depolarization of our elections or of our politics in the last couple of election cycles. And a lot of political scientists are writing about this. It's not full depolarization, obviously, especially along white-black lines, but there's been a clear diversification of the Republican Party's base, and the Democratic Party is getting whiter. And I wonder what makes Clay, one of the many aspects of Clay that's just fascinating to me is the court is, whichever way it comes down, it's going to be handing down a major ruling at a time when the ground is shifting under our feet. And, if all these trends hold up 10 years from now, it would be an easier case potentially for the court, but it doesn't know what the country is going to look like 10 years from now. So I really am fascinated to see how the justices approach such a difficult legal issue at such a difficult and unpredictable political moment.
I will say Florida is a fascinating place to be in one for many reasons, but one of them on those terms, right? This is a very kind of racially diverse state, but it's not as though racial lines track political preference in a way that, I think when the law was being developed in the 1960s applied, right? You have a state that's not merely diverse among sort of standard demographic tick boxes, but on all these big Cuban population that tends to lean more conservative, for example. So attempting to use these sort of standard established racial dynamics to predict political power and thus affect governance simply isn't as neat as it might have been at various points in the past, or as those who are trying to shape election law might have at one point predicted. So no, I think that's absolutely right. And look, I think this goes to a question of this sort of, again, it's the start of the law of freedom. Given the judicial remit, and this sort of came out in Ned's questioning about, Ned's questioning earlier. What is the judicial remit in light of these social realities, right? Given that what we want the court to do is just advance fair rule of law. To what degree should it be cognizant of these social realities? And I think part of the potential discomfort around the Jingles test is it turns the court into a quasi-administrative entity in an attempt to protect voter equality, right? So you have both a very strong rule of law element. We're trying to protect fair access to legal process through the current Section 2 test, but this can only be accomplished by a very granular intervention that almost looks like one would be more comfortable being done by the expertise of the political branches.
Well, this has been a fascinating conversation, and of course, I'm sure barely scratching the surface of both your conference last week and of the ideas in your book. So we'll look forward to opportunities to pick all this up in some future moments as well. Thank you, Jacob, for being with us today. And until next episode, we'll look forward to seeing all of you again.
Thanks so much, guys. This was a lot of fun. I've got to say, I had to, this really did, give me a chance to play with some ideas that are at the cutting edge of law. I really enjoyed speaking with all of you, and I hope to see you all in person or online. Well, in line soon and in person in not too long. Great to see you guys.
Great.